Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi, everybody. Welcome to the first episode of 2021 for the Third Fridays podcast. My name is Christian Cison, and very excited to begin a new year with new issues, of course, to discuss with you all. Thank you all for the viewership and listenership that has come in the past few months. That has increased our awareness here of the Third Fridays podcast. We're very appreciative of that. And if you want to recap on what's been happening with us in the last 2 months, 2 months ago, Christopher Major came onto the show and talked about the health insurance matching program. It's a very, very under-the-radar way to reduce a carrier's bottom line with respect to workers' compensation claims. And last month, Addison O'Donnell came onto the show to talk about a new decision from the Third Department, the Appellate Division, regarding labor market attachment. So those two episodes can be reviewed to recap you on what I've been talking about in the past 2 months. But as we flip over to the new year, I welcome my partner here at Lois Law Firm and a frequent guest, Declan Gourley. Welcome back to the show, Declan.
Thanks for having me back, Christian. I appreciate the invite. We'll start off 2021 with a bang.
There you go. So for everybody listening, I'd always planned for the January 2021 episode to discuss the medical treatment guidelines. And that's because the board was planning to roll out new body parts to be governed by these guidelines. And these include the ankle and foot, asthma, depression, the elbow, the hand, wrist, and forearm, the hip and groin, interstitial lung disease, and PTSD. Now, that is already over a 100% increase in body parts and conditions that we currently have today. So the board was making a very clear and demonstrative push to have essentially almost all treatment be governed by the medical treatment guidelines. But as all of you know, we have been in a different environment the past 8 months, and essentially the board said that the health crisis facing the state has continued to impact the ability of authorized healthcare providers to implement changes and comply with the new guidelines. A very, very key statement here from the board saying that to prevent any negative impacts to injured workers, the board has issued an order of the chair directing that these new guidelines will instead be effective on a date to be decided later. Now, ending the order of the chair or ending that notice by without giving a real date puts us in limbo. But we're still going to use the time to talk about the guidelines because there's a greater need to really understand them. Before we get into that, Declan, any commentary or any thoughts as to what led the board to make this decision, or any opinions you may have, maybe just feedback our clients and our prospective clients can take into account based on this update?
Well, considering it was open for review for doctors and providers to provide some commentary as to what they thought of the guidelines as they were proposed, to make any recommendations or any objections, I guess, I think it seems kind of fair that they would at least want to put that off until we're out of the middle of a pandemic, when maybe their thoughts are on other more pertinent matters. Again, it gets all in the eye of the beholder what's more pertinent, but it's a pretty drastic change to the workers' comp system, I think. The medical treatment guidelines that we've got in place currently are really all orthopedic in nature. And as you said, this pretty much covers everything that you're going to see in a workers' comp claim, from lung disease to PTSD and depression. We've never had psychiatric guidelines before. So this, to me, is a real game changer. And as significant a change as it is, it would make sense that we at least allow the medical community to have their full thoughts on it and the opportunity to review it.
Yeah, I don't disagree with that. I think that without a real understanding of what the guidelines are saying, it's going to be hard for any provider or any carrier or payor to determine whether treatment is within the guidelines or outside. Do you think, I mean, maybe I'm pressing a little bit further, but if there was no pandemic, do you think that healthcare providers would be completely up to date with these new guidelines? Because as we just discussed, adding all these body parts just seems like a tall task, right? We're not dealing with academics who are sitting at home. They're still treating, even if they're doing telemedicine. Would it even have been possible for these doctors to have been up to speed January 1st, 2021, if we weren't facing a pandemic?
We depose doctors day in and day out. We see what their reports say. These guidelines have been in existence for over 10 years. There's many doctors that don't know what's in the old guidelines from over 10 years ago, let alone the new guidelines that are about to be implemented. So what they know is a different story. What they willfully ignore, I guess, is a different story. But as far as getting their feedback on, as far as what their recommendations would be as to what should be pre-authorized or within the guidelines, that's where I think the hiccup probably comes and why they were at least given a little bit of a delay to review them in more detail until, I'm going to guess that there's not going to be any approval of these until the pandemic is over, hopefully soon.
Yeah, I think that's a fair guess, right? Hopefully we are using this time wisely to get up to speed, because there are some good advantages to implementing these. But let's use that to actually discuss whether it's good for either side. Do a little bit of point counterpoint. We're going to say one person is going to take the position of the medical treatment guidelines being good for employers, and the other will take the medical treatment guidelines position that it is better for claimants. Now, when we discussed this, right, we talked about how it might, on its surface, seem good for everybody, right? What better way would there be to adjudicate claims if there's clear and concise guidelines that talk about what should be approved and what should be recommended versus not? But because we litigate this day in and day out, including the depositions that you mentioned, it's not so much of a straightforward conclusion. So Declan, you wanted to take the guidelines being favorable to the employers, like the true defense attorney you are. I will take the counterpoint that they're good for claimants. And just for all our listeners out there, only for the sake of education and entertainment, I obviously am not a claimant's attorney and never plan to be one. Cross my heart. So why don't we start with you, Declan? What are some of the key advantages for employers when dealing with issues involving the medical treatment guidelines?
I think the number one benefit is the way it controls costs for medical treatment. In the state of New York, claimants obviously control medical care and where they go to. You don't get to dictate where a claimant goes, and your only real way, other than the medical treatment guidelines, to limit medical treatment is by way of an IME. And that's putting a lot of weight on an IME that might not be always the best for you. The guidelines also avoid a lot of litigation, I think, in terms of just setting forth guidelines that are straightforward and what will be approved and what's not approved. Obviously, there's always the cases that you have to litigate the issues and whether they meet the criteria or not. But I think from a carrier and employer perspective, the number one benefit is that it's a way to control costs.
Yeah, cost control is definitely an advantage for employers. I would imagine that it also favors those employers and carriers who know more about it. It's easier to dispute variance requests. It's easier to deny payment of bills if the payor, who's determining whether or not the bill will be paid, has a very complete and thorough understanding of the guidelines. And not to say that it's easy, right? It's certainly not easy. That's what we're here for whenever our clients have questions regarding those issues. But cost control is definitely one. And I would probably say from the claimant's perspective, I would want medical costs to be higher because it's going to push the employer to then want to settle to cut those costs off. So as a claimant, right, if I'm this hypothetical claimant, I'm probably thinking of ways to either get as much treatment within the guidelines as possible or simply flood carriers with variance requests themselves, right? So if I'm a claimant and I know exactly what the guidelines approve, I am actually going to pursue the treatment that's there. So I could make the argument that if you're going to expand the level and depth of treatment to say what is approved, then I'm kind of skirting along the regulation that says I need prior approval for treatments over $1,000, right? The proverbial pre-authorized surgery. I would prefer to actually just go get the surgery and bill you for it if the guidelines allow me to do that. Would you think?
Yeah, and I don't even think you have to take the step that the claimant's actually the one that has this, I want to drive up costs just for my benefit. Just look at the doctor themselves. The doctor themselves is going to want to drive up costs. They don't even have to settle the case. They just want to get more money for themselves for treatment. How often do we see cases where the doctor's submitting a request for a treatment that you go to court and the claimant's like, yeah, I don't even want that treatment. It's like, what are we here for? I think a lot of it is driven by doctors wanting to do the extra 25 sessions of PT when you've already done 3 years of it, or a surgery that maybe is not really in the best interest of the claimant, those types of things.
Yeah, that's true. Okay, so cost control, right? That's a big aspect, right? That's certainly number one for any particular issue. How are we reducing costs with any type of prospect or position within a claim? Is there anything else that's favorable to the employer or the carrier by the use or application of the medical treatment guidelines?
Again, cost to me would be the number one, and I think that's probably 1, 2, 3, 4, and 5 reasons why I would be pro. The next one, I guess, is just to have an idea of where the claim is going to head. I mean, again, like I said before, you have doctors that are 3 years into a case still requesting PT. If you know that the guidelines are not going to allow it to continue forever, it's at least giving you an end goal as to how you're going to get to the end of the case, hopefully.
Yeah, I think that's actually an outlining of what the guidelines intend to be, which is predictability, right? Having all the information out there, it is in theory designed to benefit both sides, where if I can hopefully assume as a theoretical claimant that the carrier and the healthcare provider are aware and understand what the guidelines are and what they recommend, then there should be less litigation and there should be an agreement based on how things move along as far as the medical course of treatment. I would probably say as a claimant that it's better for me because I can use the more aggressive procedures to then implement a stay or an absence from work, right? If I can pursue an authorized procedure that would implement a total disability, even if the surgery is minor, we're seeing claimants do that. And if there's a way to say that benefits the claimant, surely those types of procedures where the doctor may believe I don't need to ask for permission. I'm just going to perform this procedure based on the fact that there's a rotator cuff tear or a meniscus tear. Then I'm going to go ahead and do it, provided the prerequisites for conservative management have already been met. I would also say that a troubled claimant is probably one who has moved out of New York State, because they could probably be kind of, I don't want to say under the gun, but I guess disadvantaged, right? Because the medical treatment guidelines apply to out-of-state providers. So if that comes into play, right, what is the recourse for employers or carriers when they start seeing, let's say a New Jersey or a Connecticut or a Pennsylvania healthcare provider performing all these types of treatment, and we know for a fact that they don't know the New York State medical treatment guidelines? What does an employer do at that point?
Deny the bill and argue that or note that it's not within the medical treatment guidelines, and hopefully go to court and get an easy win when it's clearly not consistent with the guidelines. New York and New Jersey, and Connecticut, because we're so close, a lot of the doctors do treat New York workers' comp claimants, so they're more likely to be familiar. I think the benefit really comes in when you go to other states like that are further away, that they're less likely to see a New York workers' comp claim. If you go to the state of Texas, for instance, you might have never seen a New York claimant before, or even some random state like Iowa, or again, I don't want to start downplaying states, but somewhere that's less likely to see.
Really, at this time of the agreements and disagreements in our country today, you don't want to pick states over one another.
Just look at the statistics for where someone's likely to leave the state of New York and go to, and I think that the likelihood of it being the further west you go, the more or less likely it is, and the more likely that as a New York carrier or self-insured employer, you're going to get the benefit of shutting off those benefits because a doctor doesn't understand the guidelines and may just get frustrated and throw their hands up and say, I'm not going to treat you, which, again, I'm not saying one way or the other whether it's clearly it's a benefit to the carrier in most instances. And it may resolve in a quicker resolution of the claim than it might otherwise have resulted in if they were going to go to a different state and then just treat with a Texas doctor and they would just do their regular care that they would do for a Texas claimant. Maybe Texas is a terrible example for workers' comp.
What if I'm a claimant though, and I go to my out-of-state provider, and even with the understanding that the guidelines apply, right? Isn't the theory that denial of that bill and a win at litigation, isn't the theory that that's short-lived, right? It's not like that doctor that I'm now seeing out of state can't treat me anymore, right? So maybe you're controlling costs, but I'm still getting the treatment that I want. And I could also say, hey, doctor, like, if you want to get paid, here's a copy of these medical treatment guidelines, right? Is there anything stopping me from doing that? Or what about just using the guidelines as a claimant to say, well, this type of treatment, in the new guidelines, let's say, for all these new body parts, would usually cost over $1,000. But I'm imagining that once the final guidelines are issued, that there are going to be a lot of treatments that are over $1,000 but still recommended. I would say that's a big benefit to the claimant, where typically you'd have to go through this referral and authorization process for maybe that next visit of physical therapy that puts you over like a 10-week session, and now the therapy or the conservative management costs $1,100. And instead of requesting authorization, they go ahead and implement an early one-time high fixed cost to the carrier. What does the carrier do at that point then?
I think you're relying on the medical provider actually caring enough in that random state to actually figure out what the guidelines say. And I think that more often than not, if you're the one person that's walked through that doctor's office in the past 5 years that's a New York claimant, I think there's a significant likelihood that the doctor's just not going to care enough to read the guidelines and just say, I can't help you. Maybe I'm wrong. I think there's a great likelihood in the past, before that case came down, that said that they didn't have to abide by the New York medical treatment guidelines, and they just went about their business doing whatever they did in their state, and they didn't care about New York.
Incentivizing every claimant to just leave the state, right?
Right.
So if you're not subject to it, then more claimants are going to If you're saying you're not subject to it, more claimants are going to leave. Okay, so clearly, I would tend to agree with you that there is more of an agreement that the guidelines are better for the employer. But a lot of times I think that it's only based on proper application and case handling, because those variance requests have some very, very tight deadlines, right? So if I'm a claimant, aren't I advantaged by going to a workers' compensation doctor that treats workers' compensation claimants like a mill office, and just flooding a carrier with variance requests, knowing that some of them will just pass by, right? What would be the response from the employer's defense attorney to combat this kind of practice? Because we see it happen all the time.
Well, and it requires aggressive claims handling by the adjuster to make sure that they're responding and replying to all variances that they get timely. And that to me is the number one thing you need to do to combat them. Obviously, in a mill, they're hoping that 1 out of 5 or maybe 4 out of 5 get through, but it doesn't necessarily benefit every single individual claimant. It might as a whole benefit the practice, I think. So I still think that in the grand scheme of things, it benefits a treating provider in that sense more than it would a specific individual claimant. Obviously, the claimant that gets the windfall benefits, but maybe the other 4 don't.
Well, that's where I guess I would be going, right? If it benefits my treating provider, then indirectly it benefits me, because now I have more ammunition to keep my benefits going, stay out of work. And really, sometimes these variance requests are issued almost as a matter of course, right? Like you're building the case for surgery by highlighting the fact that PT, quote unquote, does not work or does not help. And I think that's the real disadvantage for employers. I think that's a lot better for claimants, because the board's use of the guidelines is based on its application of the resulting deadlines. To have a variance request be issued and then you get 30 days after an IME that's been provided notice to all parties within 5 business days from the original request, or if you don't have a new IME or records review and you're just using burden of proof to defend it within 15 calendar days, those deadlines are very, very tight.
Yes, they definitely require diligence. Don't want to take a couple of days off on vacation and not have someone else on backup to make sure they're monitoring for variances coming through to your desk.
Yeah, I think we've also seen too some success with the designated contact, right, where it goes to a particular system email address as opposed to old phone numbers or fax numbers. I think that's actually benefited employers and claimants, because the proper access to treatment is going to be swiftly adjudicated with these tight deadlines if it goes to the right person. So I can see those employers and those carriers benefiting more so by having the system in place. And in reality, that's exactly what the guidelines allow you to do. It's so capitalist in nature that it rewards the employers and carriers and the claimants and treating doctors who know the most about the guidelines. Would that be fair, or do you think that the actual ignorance that some of these treating providers have benefits them in some way?
No, I think for the most part, if it's a litigated issue, it's always going to hurt them. It's if they know what boxes to check off and know how to get them into that certain. It's a very set mold that you have to meet to get some of these medical treatment guidelines meet the criteria for. And if you know exactly what you're doing, again, we know the mills. They're always going to check off it's an exacerbation and how exactly they meet the criteria for an exacerbation. So it definitely rewards those that are familiar with it, do it day in and day out, and probably have someone just sitting at a desk that does nothing but file variances all day long.
That's a good point. Yeah, it's not even always the doctor who's doing it himself or herself, right? The staff member, or even the ability of new providers as of January 1st, 2020, to request authorization. There's going to be more forms flying out the door, and especially when email service is now acceptable in a pandemic world, the heightened intensity to respond to these variance requests is all the more clear. So Declan, any final thoughts? I think we've had a back and forth discussion here, and I'm coming to the conclusion really that COVID-19 and everything that's kind of resulted from it in our world is just giving everybody a chance to reset or put everything on hold. And guidelines are no different. I am excited to see them be implemented and help control the cost that you mentioned as the biggest advantage. But any final thoughts from you on what we can expect from the board in this type of matter?
No, I'm certainly optimistic about how they will benefit. Again, taking my side here, and what I do every day is benefit employers and carriers in handling these claims. Hopefully within the next 6 months, although I won't hold my breath on that. We'll see what happens. But I do think that they could, again, it took everyone a long time to get used to the old guidelines, and I think it will take people quite some time to get used to these guidelines. So the true benefit of it at the onset could be to the employer's advantage very quickly if they get on top of it, because treating doctors may not even be aware these exist. But I will be interested to see how this rolls out in the next year or so. I'm hoping that by January 2022, you're not still talking about when this will eventually become a thing.
I mean, I hope we're talking about a lot of different circumstances this time next year. I guess one thing I would imagine, just to kind of put a bow on it, these guidelines aren't written by lawyers. Well, some of them are on a panel, but what I do like about the board's initiative here is taking the opinion of healthcare professionals. And I really wonder if there would be a possibility for an experimental IME with a doctor who's written a portion of the guidelines. That's my final thought on this one. If we're looking for an IME to dispute a variance request, why not see if some of these doctors who are on the panel can perform IMEs, because eventually they'll be deemed credible. So that is my final take on that. Declan, thanks for appearing today. So for you, I thank our viewership and listenership for taking a listen to your opinions and comments. This is Christian Cison reminding everybody to defend from day one.